Capital punishment in the United Kingdom was used since before the creation of the state in 1801 until the practice was abolished in the 20th century. The last executions in the United Kingdom were by hanging, and took place in 1964, prior to capital punishment being abolished for murder. Although unused, the death penalty remained a legally defined punishment for certain offences such as treason until it was completely abolished in 1998. In 2004, the 13th Protocol to the European Convention on Human Rights became binding on the United Kingdom, prohibiting the restoration of the death penalty for as long as the UK is a party to the convention. Background: Sir Samuel Romilly, speaking to the House of Commons on capital punishment in 1810, declared that no country on the face of the earth in which there have been so many different offences according to law to be punished with death as, in England, known as the Bloody Code. At its height, the criminal law included some 220 crimes punishable by death, including being in the company of gypsies for 1 month, strong evidence of malice in a child aged 7 to 14 years of age, and blacking the face or using a disguise whilst committing a crime. Many of these offences had been introduced to protect the property of the wealthy classes that emerged during the first half of the 18th century, a notable example being the Black Act of 1723, which created 50 capital offences for various acts of theft and poaching. Crimes eligible for the death penalty included shoplifting and stealing sheep, cattle, and horses, and before abolition of the death penalty for theft in 1832, English law was notorious for prescribing the death penalty for a vast range of offences as slight as the theft of goods valued at 12 pence. Whilst executions for murder, burglary and robbery were common, the death sentences for minor offenders were often not carried out. A sentence of death could be commuted or respited for reasons such as benefit of clergy, official pardons, pregnancy of the offender, or performance of military and naval duty. Between 1770 and 1830, an estimated 35,000 death sentences were handed down in England and Wales, but only 7,000 executions were carried out. Reform. In 1808, Romilly had the death penalty removed for pickpockets and lesser offenders, starting a process of reform that continued over the next 50 years. The death penalty was mandatory until the Judgment of Death Act 1823 gave judges the power to commute the death penalty except for treason and murder, the punishment of death, etc. Act 1832 reduced the number of capital crimes by 2/3. In 1832, the death penalty was abolished for theft, counterfeiting, and forgery except for the forgery of wills and certain powers of attorney. Gibbeting was abolished in 1832 and hanging in chains was abolished in 1834. In 1837, the death penalty for forging wills and powers of attorney was abolished. The death penalty for rape was abolished in 1841. In 1861, several acts of Parliament further reduced the number of civilian capital crimes to 5: murder, treason, espionage, arson in royal dockyards, and piracy with violence. There were other offences under military law. The death penalty remained mandatory for treason and murder unless commuted by the monarch. The Royal Commission on Capital Punishment 1864-66 concluded that there was not a case for abolition but recommended an end to public executions. This proposal was included in the Capital Punishment Amendment Act 1868. For that date, executions in Great Britain were carried out only in prisons. The punishment of beheading and quartering those executed for treason was abolished in 1870. The last application of that punishment had been in 1820 and the last sentence to the punishment had been in 1839. In 1908, the Children Act 1908 banned the execution of juveniles under the age of 16. In 1922, a new offence of infanticide was introduced to replace the charge of murder for mothers killing the children in the first year of life. In 1930, a parliamentary select committee recommended that capital punishment be suspended for a trial period of 5 years, but no action was taken. From 1931, pregnant women could no longer be hanged, although in practice since the 18th century the sentences had always been commuted. In 1933, the minimum age for capital punishment was raised to 18 under the Children and Young Persons Act 1933. The last known execution by the civilian courts of a person under 18 was that of Charles Dobell, 17, hanged at Maidstone together with his accomplice William Gower, 18, in January 1889. Harold Wilkins, at 16 years old, was the last juvenile sentenced to the death penalty in the United Kingdom in 1932 for a sexually related murder, but he was reprieved due to age. In 1938, the issue of the abolition of capital punishment was brought before Parliament. A clause within the Criminal Justice Bill called for an experimental 5-year suspension of the death penalty. When war broke out in 1939, the bill was postponed. It was revived after the war and, to everyone's surprise, was adopted by a majority in the House of Commons. In the House of Lords, the abolition clause was defeated, but the remainder of the bill was passed. Popular support for abolition was absent, and the government decided that it would be inappropriate for it to assert its supremacy by invoking the Parliament Acts Chapter 1911 and 1949 over such an unpopular issue. Instead, then Home Secretary James Tudor Reid set up a new royal commission with instructions to determine whether the liability to suffer capital punishment should be limited or modified. The commission's report discussed a number of alternatives to execution by hanging, but rejected them. It had more difficulty with the principle of capital punishment. Popular opinion believed that the death penalty acted as a deterrent to criminals, but the statistics within the report were inconclusive. Whilst the report recommended abolition from an ethical standpoint, it made no mention of possible miscarriages of justice. The public had by then expressed great dissatisfaction with the verdict in the case of Timothy Evans, who was tried and hanged in 1950 for murdering his baby daughter. It later transpired in 1953 that John Christie had strangled at least 6 women in the same house. He also confessed to killing Timothy's wife. If the jury in Evans's trial had known this, Evans would probably not have been found guilty. There were other cases in the same period where doubts arose over convictions and subsequent hangings, such as the notorious case of Derek Bentley. The commission concluded that unless there was overwhelming public support in favor of abolition, the death penalty should be retained. Between 1900 and 1949, 621 men and 11 women were executed in England and Wales. 10 German agents were executed during the First World War under the Defence of the Realm Act 1914, and 16 spies were executed during the Second World War under the Treachery Act 1940. By 1957, a number of controversial cases highlighted the issue of capital punishment again. Campaigners for abolition were partially rewarded with the Homicide Act 1957. The act brought in a distinction between capital and non-capital murder. Only 6 categories of murder were now punishable by execution: in the course of furtherance of theft, by shooting or causing an explosion, while resisting or arrest during an escape, of a police officer, of a prison officer by a prisoner, the second of 2 murders committed on different occasions. The police and the government were of the opinion that the death penalty deterred offenders from carrying firearms, and it was for this reason that such offences remained punishable by death. Abolition. In 1965, the Labour MP Sidney Silverman, who had committed himself to the cause of abolition for more than 20 years, introduced a private member's bill to suspend the death penalty, which was passed on a free vote in the House of Commons by 200 votes to 98. The bill was subsequently passed by the House of Lords by 204 votes to 104. The Murder Act 1965 suspended the death penalty in England, Wales and Scotland for murder for a period of 5 years, and substituted a mandatory sentence of life imprisonment. It further provided that if, before the expiry of the 5-year suspension, each House of Parliament passed a resolution to make the effect of the Act permanent, then it would become permanent. In 1969, the Home Secretary, James Callaghan, proposed a motion to make the Act permanent, which was carried in the Commons on 16 December 1969, and a similar motion was carried in the Lords on 18 December. The death penalty for murder was abolished in Northern Ireland on 25 July 1973 under the Northern Ireland Act 1973. Following the abolition of the death penalty for murder, the House of Commons held a vote during each subsequent Parliament until 1997 to restore the death penalty. This motion was always defeated, but the death penalty still remained for other crimes: causing a fire or explosion in a naval dockyard, ship, magazine or warehouse; espionage; piracy with violence; treason; and certain purely military offences under the jurisdiction of the armed forces, such as mutiny. Prior to its complete abolition in 1998, it was available for 6 offences: serious misconduct in action, assisting the enemy, obstructing operations, giving false air signals, mutiny or incitement to mutiny, and failure to suppress a mutiny with intent to assist the enemy. However, no executions were carried out in the United Kingdom for any of these offences after the abolition of the death penalty for murder. Nevertheless, there remained a working gallows at HMP Wandsworth, London, until 1994, which was tested every 6 months until 1992. This gallows is now housed in the Galleries of Justice in Nottingham. Last executions, England and in the United Kingdom. On 13 August 1964, Peter Anthony Allen at Walton Prison in Liverpool, and Gwyn Owen Evans at Strangeways Prison in Manchester, were executed for the murder of John Allen West on 7 April that year. Scotland, Henry John Burnett, 21, on 15 August 1963 in Craiginches Prison, Aberdeen, for the murder of Seaman Thomas Guyan. Northern Ireland, Robert McGladdery, 26, on 20 December 1961 in Crumlin Road Jail, Belfast, for the murder of Pearl Gamble. Wales, Vivian Teed, 24, in Swansea on 6 May 1958, for the murder of William Williams, sub-postmaster of Forest Vark Post Office. Last death sentences: Northern Ireland and in the United Kingdom. Liam Holden in 1973 in Northern Ireland, for the capital murder of a British soldier during the Troubles. Holden was removed from the death cell in May 1973. In 2012 his conviction was quashed on appeal. England, David Chapman, who was sentenced to hang in November 1965 for the murder of a swimming pool night watchman in Scarborough. He was released from prison in 1979 and later died in a car accident. Scotland, Patrick McCarron in 1964 for shooting his wife. Ironically, he hanged himself in prison in 1970. Wales, Edgar Black, who was reprieved on 6 November 1963. He had shot his wife's lover in Cardiff. Final abolition. The Criminal Damage Act 1971 abolished the offensive arson in royal dockyards. The Naval Discipline Act 1957 reduced the scope of capital espionage from all spies for the enemy to spies on naval ships or bases. Later, the Armed Forces Act 1981 abolished the death penalty for espionage. Beheading was abolished as a method of execution for treason in 1973. However, hanging remained available until 1998 when, under a House of Lords amendment to the Crime and Disorder Act 1998, proposed by Lord Archer of Sandwell, the death penalty was abolished for treason and piracy with violence, replacing it with a discretionary maximum sentence of life imprisonment. These were the last civilian offences punishable by death. On the 20th of May 1998, the House of Commons voted to ratify the Sixth Protocol of the European Convention on Human Rights prohibiting capital punishment, except in time of war or imminent threat of war. The last remaining provisions for the death penalty under military jurisdiction were removed when Section 21 of the Human Rights Act 1998 came into force on 9 November 1998. On 10 October 2003, effective from 1 February 2004, the UK acceded to the 13th Protocol, which prohibits the death penalty in all circumstances. As a legacy from colonial times, several states in the West Indies still had the British Judicial Committee of the Privy Council as the court of final appeal, although the death penalty has been retained in these states. The Privy Council would sometimes delay or deny executions. Some of these states severed links with the British court system in 2001 by transferring the responsibilities of the Privy Council to the Caribbean Court of Justice to speed up executions. Crown dependencies, although not part of the United Kingdom, the Isle of Man and the bailiwicks of Guernsey and Jersey are British Crown dependencies. In the Channel Islands, the last death sentence was passed in 1984. The last execution in the Channel Islands was in Jersey on 9 October 1959, when Francis Joseph Fouché was hanged for murder. The Human Rights Order 2006 amends the Human Rights Law 2000 to give effect to the 13th Protocol of the European Convention on Human Rights, providing for the total abolition of the death penalty. Both of these laws came into effect on 10 December 2006. Capital punishment was abolished in Guernsey in 2003, and the 13th Protocol was extended to Guernsey in April 2004. SARC formally retained it until January 2004, when the Chief Pleas in a 14-9 vote removed it from the statutes. The last execution on the Isle of Man took place in 1872, when John Cuish was hanged for patricide. Capital punishment was not formally abolished by Tynwald until 1993. 5 persons were sentenced to death on the Isle of Man between 1973 and 1992. Although all sentences were commuted to life imprisonment, the last person to be sentenced to death in the UK or its dependencies was Anthony Dare, who was convicted at the Manx Court of General Jail Delivery in Douglas for contract murder in 1992. He was subsequently retried and sentenced to life imprisonment in 1994. In 2004, the 13th Protocol was adopted, with an effective date of 1 November 2006. Overseas territories. Like the Crown dependencies, the British Overseas Territories are constitutionally not part of the United Kingdom. However, the British government's ultimate responsibility for good governance of the territories has led it over recent years to pursue a policy of revoking all statutory provision for the death penalty in those territories where it had up until recently been legal. The last executions in an overseas territory, and indeed the last on British soil, took place in Bermuda in 1977, when two men, Larry Tackleton and Erskine Burrows, were hanged for the 1973 murder of the territory's then-Governor Sir Richard Sharples. In 1991, the British government extended an order-in-council to its Caribbean territories whose effect was to abolish capital punishment for murder. Anguilla, the British Virgin Islands, the Cayman Islands, Montserrat and the Turks and Caicos Islands. The British government was unable to extend the abolition via order-in-council to Bermuda, the UK's most autonomous overseas territory with powers of almost total self-governance, but warned that if voluntary abolition was not forthcoming, it would be forced to consider the unprecedented step of whether to impose abolition by means of an Act of Parliament. As a result, the Bermudian government introduced its own domestic legislation in 1999 to rectify the problem. Further measures were subsequently adopted to revoke technicalities in British overseas territories' domestic legislation as regards use of the death penalty for crimes of treason and piracy. In October 2002, the British government abolished the death penalty for treason and piracy in the Turks and Caicos Islands. Since then, the death penalty has been outlawed under all circumstances in all the UK's overseas territories.